What's up, everybody? Welcome back into another episode of The Lawyer You Know, and it's another day, another set of documents here in the Karen Reed case. We're going to go through some of the new motions that were filed. Will she be able to put some kind of earpiece in to listen to the sidebar? What documents have the Commonwealth turned over here right before trial number 2? And yet another order from the judge on one of the Commonwealth experts. What did she do? Are you going to be surprised? I doubt it. And then if we have time, we will take a look at the Vanity Fair exclusive article on the juror from trial number 1 becoming defense attorney for trial number 2, only in Karen Reed's case. That's still mind-blowing to me, so let's get to it. So we got an idea of how this motion is going to go, and I'm pretty confident, I think, in what the outcome is going to be as to whether or not the defense is going to get their way where she can get some kind of earpiece in. That's not a big deal for her to listen to sidebar. The judge said she can walk up the sidebar like every other defendant. It is her right, but we're not going to necessarily give her some kind of listening device. Now, we have seen trials where the defendant has walked up. Some of you guys are like, that's weird. Why is that happening? Defendants have that right in their criminal trials. But we've also seen defendants with headphones or earpieces in to listen to what's going on sidebar. It's less clunky, less moving around. Judge Cannone does not seem inclined to do that. But if the defense can provide an argument and some reason why that is compelling enough, it is definitely within Judge Cannone's discretion to give the defense what they want and let Karen Reed wear headphones or some kind of an earpiece instead of having to come up for every sidebar. Let's see what they argue. Now comes the defendant, Karen Reed, and respectfully moves this honorable court to grant her audio access to sidebar bench conferences throughout all critical stages of the proceedings, including individual voir dire. A criminal defendant is entitled to a trial by an impartial jury pursuant to 6th Amendment to the United States Constitution, Article 12 of the Mass Constitution Declaration of Rights, per Mass Superior Court Rule 6. The trial judge in each case has discretion to determine a procedure for examining and selecting jurors designed to maintain juror privacy and dignity, identify explicit and implicit bias, and foster efficiency in the session. A defendant's use of headphones at counsel table to participate in sidebar conferences, including juror voir dire, is an efficient way to ensure participation in all critical stages, mitigate concerns that jurors will not feel comfortable answering questions honestly and openly in the presence of the defendant, and eliminate the risk of prejudice to the defendant. So there's a couple ways to look at that first statement. Number one, don't we want jurors to know what's happening? Are they going to say something thinking the defendant's not listening, but the defendant actually is? We want to be honest with the jurors. So I understand people with that point of view. But on the other side, the most important part of voir dire is juror honesty, transparency, just determining if they have some bias and they're not right for this jury. If they don't, great. Let's put them on this jury. That is the most important part of voir dire. And frankly, you're not saying the defendant can't hear if they come up and talk. It just may be different to look somebody in the eye and say it versus say it at sidebar. That's a normal, just humanistic, personal feeling that a lot of people have. Some people don't, of course. For the following reasons, Ms. Reed respectfully requests this court exercise its discretion and grant her audio access to sidebar bench conferences throughout all critical stages of the proceedings, including individual voir dire. Ms. Reed has the right to be present during all critical stages. Ms. Reed has the right to be present during all critical stages of the proceedings, including voir dire. The defendant shall be entitled to be present at all critical stages. We all agree on that. Judge Cannone is going to agree on that. The right to be present is derived from the Confrontation Clause of the 6th Amendment to the United States Constitution and Due Process Clause of the 14th Amendment and Article 12 of the Massachusetts Declaration of Rights. Critical stages has been defined to include jury selection. It is improper to deny the defendant the privilege of being present at voir dire if an appropriate request for his presence is made. And that's what's happening here. They're making that request, but they're making it in a specific way. Ms. Reed's meaningful participation in voir dire is necessary for her right to a trial by an impartial jury. Ms. Reed's meaningful participation during the critical stage is of the utmost importance to her right to a trial by an impartial jury. The lack of adequate voir dire may impair the defendant's right to exercise peremptory challenges. A defendant's presence when jurors are being examined and is necessary in order to aid counsel in selection of jurors and exercise his peremptory challenges. We know how involved Karen Reed has been in her defense, how involved she's been in their strategic moves, how involved she has been in this case. She's definitely going to want input here into voir dire. And maybe, just maybe, that new defense lawyer, who in fact was a juror on the last trial, will have some input during voir dire as well. The right to exercise peremptory challenges provided by Mass GLC 234, Section 29, has been called one of the most important of the rights secured to the accused. In my opinion, jury selection, most important part of a trial. Ms. Reed is a member of the community in which she will be tried and might be sensitive to particular local prejudices, which her attorneys may not readily identify. Frankly, we've seen it in some of the cop texts, right, about where she's from and what her accent is like. Noting that defendants have unique knowledge, which is important at all stages of the trial, including voir dire, and may have knowledge of facts which may not have been disclosed to counsel prior to trial, but which may become important as the individual prejudices or inclinations of the jurors are revealed. Ms. Reed has remained thoroughly involved in her trial strategy throughout all prior proceedings, and it would be improper to deny her the privilege of being present for sidebar conferences during juror voir dire. Ms. Reed respectfully requests this court to afford her the chance to be present through the use of headphones at counsel table to enable her presence and secure her right to a trial by an impartial jury. The trial judge in each case has discretion to determine a procedure for examining and selecting jurors designed to maintain juror privacy and dignity, identify explicit and implicit bias, and foster efficiency in the selection. Granting Ms. Reed access to sidebar conferences via headphones at counsel table is within the court's discretion. Conclusion. Granting Ms. Reed audio access to sidebar conference at counsel table during voir dire is within the court's discretion and will allow her to meaningfully participate in identifying implicit and explicit bias among potential jurors. Additionally, limiting the number of individuals crowding the bench during sidebar conferences will foster efficiency during the voir dire process. Ms. Reed's meaningful participation in the voir dire process can be facilitated by the use of headphones at counsel table. Avoiding overcrowding at sidebar conference is an important logistical consideration for both efficiency purposes and ensuring jurors feel most comfortable answering honestly. Submitted Alan Jackson Little, etc. So here's what I'll say, and we're going to leave this conclusion paragraph on the screen for a second. They needed to convince Judge Cannone that this is necessary. This is the only fair way to handle the process, and they needed to give reasons why logistically. They focused on her right to be involved at all critical stages. They focused on the fact that jury selection is one of those stages. I think they're correct. I think they've convinced Judge Cannone of that. I think Judge Cannone agrees with that. I think Judge Cannone agrees that she has a right to be involved in sidebar conferences during jury selection and during the trial, all critical stages. But what I don't think they really did here was spend enough time convincing Judge Cannone to take the additional step, which we all know some judges just allow it and don't have a problem with it. We know Judge Cannone at first just said absolutely not, but you can go ahead and brief it and send it in to me. She can come up and walk up with everybody else. I'm not going to give her headphones. And she may even say, all 5 of you lawyers don't have to come up, right? You can send 2 lawyers, 1 lawyer, 3 lawyers, 4 lawyers, if you're really worried about overcrowding, and then you can share information with your other lawyers. They can say, that's not how we want to defend the case. We have the right to defend the case. She has a right to counsel, and we're going to do the best of our ability. So we all want to be there, and that's fine if they want to do that. But again, what are you worried about if it's just overcrowding and Karen Reed is so important to be there, then have one of your other lawyers sit down. Lots of cases are tried without 5 lawyers walking up to every sidebar. And I think that would be a reasonable conclusion from Judge Cannone. I think based on this motion, it's reasonable for Judge Cannone to do what she thinks is right and best, which it seems to be have Karen Reed come up at counsel table. Is that what I would do? Probably not. I like a cleaner, smoother trial. I'd rather her just be able to sit over there and listen to everything. That's probably what I would do just for ease and for comfort. Judge Cannone, I don't know what her reasoning is. Maybe she'll tell us what her reasoning is. Seems like she defaults and kind of leans into she can come up with everybody else. So I don't think there's anything in this motion that's going to convince her otherwise. Personally, maybe she will. Maybe she'll change her mind. Maybe especially this conclusion paragraph, which did say overcrowding at the bench will foster inefficiency. So to avoid overcrowding will be more efficient, which I tend to agree with that. Maybe that will convince Judge Cannone. I don't think so. We'll see. I don't think this is a big deal, by the way. Either way, my argument may have been, Judge, during the last trial, we know that certain jurors made decisions based off Karen Reed's facial expressions. And there were news articles about what she was wearing in court. Was it too professional? Was it not professional enough? Did she look too rich or too poor? And getting up and walking to counsel table every time, that could create an issue where jurors think they can learn something from her walk, right? Like maybe if she stumbles, well, was she drinking today? This is a case about drinking and driving. Some of the physical issues that Karen Reed deals with, the medical issues, are they going to try to look for that? Is it real? Is it fake? Is she trying to garner sympathy from every time she walks up the counsel table and sits down? That's a big deal in personal injury cases, right? If you have a back injury or a leg injury, how are they walking? Well, they look perfectly fine to me. Whatever it may be, it happens when they walk to the stand. But if they're getting up and sitting down and walking to sidebar every single time. The jury could be making presumptions or decisions based on that, and that is not a relevant issue for them to consider in this case. Therefore, multiple reasons: efficiency in the courtroom, smoothness and cleanness of the trial, and not getting anything that shouldn't be admissible evidence from Miss Reed standing up and walking to sidebar each time. I may have put in some more of those arguments, but they did what they did here, and we'll see what Judge Cannone determines there. Then we have the Commonwealth's notice of additional discovery here. We're going to focus on a couple. We have a transcript with Ted Daniels, transcript of William Reed and Janet Reed. That was of Karen Reed. We have emails to Brennan and Lally and audio files. We've got a final report by attorney Stephen Sack. We have the docuseries, the defendant's information from the docuseries, transcripts of what they said. And then we finish with a copy of the updated PowerPoint by Dr. Judson Welcher, 140 slides, dated 3/24. So this is, the defense had already seen this, and Alessi was like, we were under the impression it was going to be pared down. It was not pared down like they said it would be. Why was it not? Will Judge Cannone care about that? It's really frustrating and annoying if they give you a PowerPoint that has all sorts of stuff everybody agrees it is inadmissible. Give us what you actually plan to present, what you actually plan to use with the expert, so we can have our expert look at it, respond to it. We can prep our cross-examination on it, and we know what we need to fight about or what we don't need to fight about, because my guess is we don't agree exactly which portions of this are admissible or not admissible. Doesn't seem like they pared it down at all. Well, let's see if that affected Judge Cannone's decision on Welcher. And I think the answer is going to be no. She is going to let Welcher testify. She is going to let him use a PowerPoint, in my opinion, and she is going to allow the Commonwealth to not turn over exactly what that PowerPoint is. Because even in yesterday's hearing, she did not force them to turn over only what would be testified to. She did not force them to pare down a 140-point PowerPoint. So that would have been the appropriate time. So once again, this is not something that is affecting her decisions on the Commonwealth's experts. And frankly, I don't think it should be a reason to strike the Commonwealth expert. I don't think it should affect her a reason of whether or not she's going to allow an expert to testify. But you should absolutely provide the other side with specifically what the expert opinions are, what the testimony is, what the backing is, and what they plan to testify to, especially with no depositions and especially with no Daubert hearing. So the defense would get a free crack at cross-examining the witnesses. Because if you notice, every time Brennan gets a Daubert hearing, he knows exactly what they're testifying to, exactly what they're relying on. So if there were inadmissible issues they want to testify to, they could handle it before trial. All right. And let's look at the next motion. This one's actually in order. Memorandum of decision and order on defendant's motion to exclude the purported expert testimony of the Commonwealth's proffered witness, Dr. Wolf, and requesting for a Daubert-Lanigan hearing. So will she strike Dr. Wolf? Or at the very least, will she give the defense, again, a free crack at him with a Daubert hearing? Go ahead and put in the chat what your guess is. Let me know. After hearing and review of the pleadings, the court finds that the Commonwealth has satisfied the foundational requirements set forth in Daubert and Lanigan. The proposed witness is qualified as an expert to testify that the head injuries sustained by the victim in this matter are consistent with falling backwards and striking his head on the frozen ground. Isn't that interesting? So I don't disagree with her at all. I think this expert is absolutely qualified to talk about head injuries and how you can cause a head injury by hitting your head on the ground. Now, how far is she going to let him testify to the fact that the ground is frozen? If I'm the Commonwealth here, I'm the Commonwealth and I get this order, I am absolutely having this witness testify that he hit his head on frozen ground. Maybe I won't get into all the science about how I know it's frozen or how hard it is or how hard it needs to be, but the judge has clearly stated in her order he can say he hurt his head by falling backwards and striking it on the frozen ground. If I'm the defense, I take issue with this. I need clarification on this. Judge, are you really going to let him say frozen ground? Or just, if the ground is hard enough and you hit your head, it can cause this injury. That's how the doctor should testify, and they should have somebody else that's an expert testify to how hard the ground is, or even maybe a layperson that said, I went and felt this ground, because guess who didn't feel this ground? Dr. Wolf. So while he is, in my opinion, qualified to talk about the head injury and how it could occur, not qualified to talk about how hard the ground was. Dr. Wolf has the requisite education, training, experience, and familiarity with the subject matter of the testimony to qualify him as an expert. He is a board-certified neurosurgeon with over 35 years of experience. He graduated from Yale Medical School and has held numerous faculty positions at various university hospitals for the last 3 decades. You're not going to hear me complain that he can't testify about this. I know people are trying to nitpick and say he shouldn't be able to say this, that. That's not his expertise. This is, in my opinion, neurosurgeon with this background can testify about how head injuries can occur. He's the founder and the medical director of the Miami Neuroscience Center. He has authored many publications in his field of expertise, including several peer-reviewed articles and numerous book chapters and journal articles related to head injuries. Thus, it is clear Dr. Wolf's is adequately qualified to offer his expert opinion at trial. The Commonwealth has also shown that the methodology or theory underlying the expert testimony is sufficiently reliable to be presented for the jury's consideration. As noted, in addition to Dr. Wolf's many years of experience treating head injuries, he has also authored numerous publications concerning, among other things, the treatment and management of brain injuries and specifically fractures of the clivus. Based on his experience and published literature, his report adequately explains the connection between the force needed to incur specific skull fractures, the skull fractures incurred by the victim in this case, the physical consequences resulting from such injuries. Therefore, his proposed testimony that the victim's injuries were consistent with falling backwards and striking his head on the frozen ground, not on frozen ground, generally, like if you hit frozen ground, but is he going to be able to say that ground was frozen? Has the scientific basis and reliability necessary to be admissible to the jury. So whether we agree with this or not, I tend to agree with it generally, minus the frozen ground part. Isn't this funny, right? And this is why I like comparing apples to apples. Judge Cannone actually gave us some specifics about the methodology and the theory and the scientific reliability of a very legitimate neurosurgeon who deals with brain injuries. She gave us how she finds the methodology and the theory to be reliable. Let's just remember, did she do that in every order for an expert who has the same exact standard for methodology and theories being reliable and generally accepted? I'll let you guys tell me what you think in the chat, if that's the same across the board for all of the experts in all of her orders. And hit the like button if you guessed right on what the outcome of this order was going to be. For the foregoing reasons, the defendant's motion to exclude the purported expert testimony of the Commonwealth's proffer witness, Dr. Wolf, and request for a Daubert Lanigan hearing is denied. So they don't even get a hearing. No surprise there. All right. The last document we are going to take a look at here is the Vanity Fair article. Is there a way for me to make it more viewable? I guess I can make myself smaller. There we go. All right, let's take a read here. When Victoria Brophy George got the jury summons for the first Karen Reed trial outside of Boston in 2024, she didn't balk. A Princeton graduate who grew up obsessed with the Supreme Court, interned with a federal judge, and got her JD from Northeastern University School of Law in Boston. George says she feels a civic obligation to participate in the oft-dreaded enlistment. She was also pregnant at the time. So I'll just tell you, most time, if we have pregnant women in our Vanity and they say, I want out, we say, okay. I don't know what you're going through. Maybe some of the women here, in the courtroom do. Nobody's going to force you to sit here when you're pregnant, right? There are physical incapacities, back injuries, people that have hearing problems, language barriers. There's all sorts of physical things that allow people hardships so they don't have to sit on a jury. And guess what? They could have sent Miss George home. Nobody would have been mad. And she could have showed up next year when she was no longer pregnant, right? I mean, having kids and infants and everything, you could say it's always difficult, right? I know about that life. I've got kids. But you have a hardship, you come back next time and you do your duty. She didn't do that. By the time she turned 34 last year, the employment lawyer had already served on 2 prior juries and acted as a foreperson. So what does that tell you about her? People that serve on multiple juries are generally fair and impartial. They generally walk into a situation unbiased. And this Commonwealth, in this case, trial number 1, felt the same way. And so did the defense. George had heard about Reed. The Massachusetts woman was all over Boston media as the prime suspect in the mysterious 2022 death of her Boston police officer, John O'Keefe. Norfolk County DA Michael Morrissey charged then 42-year-old equity analyst with second-degree manslaughter while operating under the influence of alcohol and leaving the scene of personal injury or death. Prosecutors allege that In a drunken rage, she had fatally backed her SUV into O'Keefe and left him to die in a blizzard. As Reed told Vanity Fair last year in a two-part feature, she believed that she was being framed as part of a cover-up involving Morrissey and the Massachusetts State Police Detective Michael Proctor. George, who joined Reed's legal team on Wednesday, which is wild, was too busy caring for her two small children and grieving for her mother who died in 2023 to pay much attention, and was therefore qualified as a juror. I was able to be a juror because I believed that the court system was going to give her a fair trial, she told Vanity Fair weeks before she joined. I've been trying to continue to believe in justice for a while. George is a conscientious rule follower. Once during trial, after she drove past a Free Karen Reed billboard outside of Gillette Stadium, she told Norfolk County Superior Court Judge Beverly Cannone to make sure she was on the up and up. The court assured her she was. And by the way, some people are going to be like, she's annoying. She was inserting herself in the process. We lawyers, and I can speak as a we because I'm also a lawyer, sometimes over communicate. Sometimes, especially when there's rules involved and we know we're lawyers. And this is why I say she's not a plant. She's not in there committing fraud on a runaway jury situation, right? We are so worried about breaking a rule and doing something unethical, or at least most of us, I should say, that we want to make sure everybody knows. Like when I'm in an elevator already during a jury trial and a juror gets on because they forgot what the judge said, I look at the floor and I let everybody know when I get to the courtroom that juror number 6 ended up in the elevator with me. I did not say anything to them. If I smile at them when I walk in, I say I smiled at them when I walked in. It was just my normal course. I wasn't trying to do anything. It was just habit in my reaction. That's just how a lot of lawyers are. And that's how I think George is. During 9 weeks of trial, she says that she and the other jurors stretched conversation limits to avoid talking of the case, which could not begin until deliberations. When another fellow juror began to openly criticize Reed before deliberations began, according to several jurors, she and her peers reported the person to Cannone. The jury they reported was dismissed. So what's interesting is there's been some talk was George the juror from the bar who got booted because the cop said she was talking about the Karen Reed case? I tend to think no, because she was cut as one of the alternates. But then I understand why some people think yes, because she says she criticized a juror or told the judge about a juror who was criticizing Reed, and that juror got bounced. And that was some of the background for the other juror that got struck. So I don't know the answer to that. I think the answer is no, but I'm not positive. For George, the Fulcrum trial moment, and I haven't read this whole article, so maybe we'll find out here, because a bunch of people sent me this. I figured we'd read it together. For George, the Fulcrum trial moment was when Massachusetts State Police Trooper, former Michael Proctor, the lead investigator on Reed's case, read aloud the text messages he had sent friends and supervisors only 16 hours into the investigation. There will be serious charges brought on the girl. She's a whack job C-word. Zero chance she skates. She's effed. When someone on the text chain surmised that the homeowner on whose property O'Keefe was found would surely receive some shit as well, Proctor responded, nope, homeowner's a Boston cop too. Proctor later called the text unprofessional and regrettable. Earlier this month, the Massachusetts State Police fired Proctor for unprofessional conduct during the investigation of Reed, and something that looked like it was a bias in the investigation. Knowing he was the lead investigator, says George, and based on his own words, he had pretty much strong personal bias against the person in the defendant's chair. How do you ever trust the evidence coming from his investigation? I may have characterized it a little bit differently than George, but generally speaking, I get where she's coming from. On the day of closing arguments, a juror who appeared sympathetic to the defense was dismissed. I believe that was the juror who was heard at the bar from the cops and didn't know necessarily whether she said something or not. As revealed in court early this month, the dismissal was prompted by MSP officer John Fanning. Okay, so this article agrees. One of Proctor's supervisors, who's Reed's lawyers, Alan Jackson, says had been on the whack job text chain. Fanning was, which is why he should just have nothing to do ever with this case. While huddled at Sidebar to discuss the reason for the juror's dismissal, Reed's lawyers, Jackson, Yannetti, Little, learned that Fanning, an investigator on the case working out of Morrissey's office, had that morning reported an alleged incident he had not personally witnessed that supposedly took place several weeks prior. There was no evidence presented at the time, as the court knows, Jackson told Cannone during a fiery exchange on this motion to dismiss argument on March 5th. There was no declaration, no report, no supporting documentation whatsoever. Over the defense's objection, this very potentially defense-friendly juror was then excused. I asked the court to take evidence from Lieutenant Fanning. The court declined that invitation. Cannone did not dispute Jackson's recollection of those events, but asserted that Fanning did not have direct or indirect access to the jury. In the state of Massachusetts, alternate jurors are selected at the end of trial. Several hours after the aforementioned juror dismissal, the clerk magistrate rotated a box on a spindle and pulled out 2 tiles. He did not know the numbers. He didn't show the numbers to the court, but said they belonged to George and another juror who had reported the critical juror to the judge. So the 2 alternates that were not going to be deliberating were the ones that reported a juror who was anti-defense. And again, that could all be by chance. That could all be happenstance. There was obviously multiple jurors in there that were still pro-defense, hence the hung jury. But 3 jurors were struck that were potentially pro-defense, one of whom by testimony from Fanning and other cops, the other 2 randomly. Interesting. But to see both sides of the argument, a pro or an anti-defense juror was struck earlier in the trial. Cannone could have said, no, I think she's fine. Let's let her stay. I keep saying she. I don't know if any of these jurors were male or female, besides Miss George, of course. But she could have tried to keep that anti-defense juror on. She didn't. She struck that juror as well. So George requested a sidebar with Cannone. Isn't that funny? A lawyer's like, excuse me, I have something to say. As she recalls, saying that their dismissal from the voting pool did not seem like a coincidence. Cannone declined to comment for this story. George had hoped her legal skills could be helpful in the deliberation room, as they had during a previous trial during which she had served as a foreperson. So theoretically, that's one of the reasons that lawyers don't want another lawyer on their jury, because they don't want one juror making the decision. And so many times, if you have a cop or a lawyer on there, everybody looks to the lawyer, the cop, and they're like, what should we do? What does this mean? How does this work? And unless you really love that juror and you think they're on your side, you usually do not want them on the jury. So I have a very strong feeling the Commonwealth is not going to want any lawyers on this jury. In the state of Massachusetts, the judge chooses the foreperson based on a number of factors such as attentiveness through trial and demeanor. Other times, the decision can be made arbitrarily based on seat number. To preside over the fate of Reed, a woman being charged with fatally hitting her police officer boyfriend, Cannone selected a retired police officer to act as foreperson. During the trial, according to 2 jurors, the cop told his peers that he had been hit by a car. According to multiple jurors who have come forward since the mistrial was declared, there was confusion in the deliberation room whether or not the jurors could declare a partial verdict, even though the jurors were unanimous in deciding Reed was not guilty of second degree and leaving the scene. They were split on the manslaughter charge. Yet the letter from the foreman that Cannone read aloud in the courtroom indicated they were deadlocked on all charges, plural, and a mistrial was declared. So interesting reporting, right? And I don't know exactly where they got this quote. It's not a quote, but they admit it could just be this author. It could be George. It could be from the other juror interviews that the note said they were deadlocked on all charges, plural, which means as far as Judge Cannone is concerned, and as far as the higher courts and the appellate courts were concerned, they have to go by that jury note. And if the jury note, this author or maybe multiple jurors agree, didn't say what it should have said, that's what the court has to go for. And without what I thought should have happened, a juror interview where Cannone brought people in and asked them questions that were on the jury, without that, I think it's a losing battle for the defense, unless, of course, the prosecutor wants to do the right thing and not prosecute those charges. Reed has appealed the verdict, claiming that her constitutional rights are being violated by being tried for M a second time. George has 4 children under 5, including infant twin sons, and had no desire to come forward. I waited for nearly a year after the mistrial, hoping the court system would work as intended to remedy some of the wrongs in this case, she says. During the March 5th pretrial hearing, Jackson argued that Reed's case should be dismissed for reasons of extraordinary government misconduct, including Proctor's bias, investigative failings, the suspicion of jury impropriety, and the fact that some video evidence was withheld from Reed until January 25th. On Tuesday, Cannone rejected Reed's request for an evidentiary hearing about the recently surfaced video, which the Commonwealth has called an oversight, and denied Reed's motion to dismiss because the claim violations here do not rise to the level that would justify the draconian sanction of dismissal, and because the defendant's constitutional rights can be fully protected in the coming trial. But it was how Hank Brennan, everybody was hopeful would come in here and be even-handed and make sure the defendant got a fair trial. The special prosecutor Morrissey appointed to try the Reed case this time around responded to Jackson's allegation of jury tampering that compelled George to speak up. So Brennan has, in fact, had a public effect on this case. Brennan, who previously defended Whitey Bulger in federal court, suggested Reed's claim of extraordinary government misconduct were dangerous and reckless, with the potential to cause the public to question the fabric of our entire judicial system. George tells Vanity Fair, attorney Brennan implied that the defense was responsible for causing sentiments of distrust in the justice system simply by questioning inconsistencies, inconvenient facts, and missing evidence. At that point, she decided, if as a lawyer I was too afraid to stand up for what I believed in, who would? Even after the circumstances of her dismissal from the deliberating jury pool and the contested mistrial verdict, George had been helpful when Brennan was assigned to the case. The respected Boston lawyer released a statement last fall saying that one of his core obligations was to make certain Karen Reed receives a fair trial and the dignity and fairness that every defendant deserves in our criminal justice system. Says George, I was impressed by his background and naively thought he would see the overwhelming evidentiary issues with the case against Karen Reed at minimum. I thought he would encourage the Norfolk County District Attorney's Office to dismiss 2 of the charges given constitutional double jeopardy concerns. George was bothered by another seeming constitutional right at risk in Reed's case, her entitlement to the defense of her choosing. Oh, so Betterow also had an effect on this. Earlier this month, Cannone denied Reed's request to add Mark Betterow, a former Manhattan Assistant District Attorney, to her team. Because Betterow represents Aidan Kearney, the blogger known as Turtle Boy, Cannone determined that Reed retaining him would constitute a conflict of interest that is not waivable. George called Jackson shortly after. So George reached out to Alan Jackson shortly after seeing the ruling to express her mounting frustration as Reed's second trial approached. George joked that she is still licensed to practice law in Massachusetts should Reed need an extra set of hands. Over the course of the conversation, the suggestion became less of a joke and more of a potential reality. On March 26, Reed filed a motion to add George to the team. The case has garnered so much media attention and so many polarized reactions that George hopes the public and future jurors can remember that two things can be true at once. What happened to John O'Keefe was a tragedy, says George, but just because something is sad doesn't mean the person in the defendant's seat is responsible. I can feel bad for his family and believe she's not guilty at the same time. Correction. This article has been updated to reflect that the 4-person selected to the first trial was a retired police officer, not a retired Boston police officer, who told his peers he had been hit by a car, according to 2 jurors. So this quote here, if I had to guess how juror/lawyer George sees this case, it is more of a reasonable doubt, and from her other quotes, bad investigation, bad cop in Proctor, bad prosecution, bad discovery violations by the Commonwealth. That is reasonable doubt, and that is why Karen Reed is not guilty. I'm not sure how strongly she feels about the conspiracy. Maybe we'll find out one day. We'll see. But isn't that interesting? So thank you to everybody that sent me that. Thank you to Ashley again for always updating me on the documents. What you send, I review, because people are always asking me about all of this on Twitter and Instagram as well. Make sure you follow us on there if you haven't already, at Tragos Law on Instagram. We post a bunch of stuff on there about the case as well, and at Lawyer You Know on Twitter. Make sure you're subscribed here as well, and that you've hit that like button. Hit the like button if you haven't already. It's awesome to hang out with you. Till next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.